Thank you, Madam Chair, Dr. Swanson, Dr. Newick, Dr. Archibald. Like the previous speaker, it's been my privilege to participate in long hearings like this as he did, so I echo his comments about congratulations and condolences to the three of you. And I join him in thanking you for your effort and your expertise on behalf of Canadians. I have filed, as you know, a written submission which has 10 pages of text. I've been allotted 10 minutes. I will speak to the written submission. I apologize for not having slides. I will let you know as I proceed through it where I am in that submission. There are a few places where I must of necessity read for precision, but I'll go through it just as expeditiously as I can. My short bio is on page 1. I spent a number of years practicing environmental and criminal law, both for the public sector and in the private sector. Spent some years as Deputy Minister of Environment, Ontario, and Deputy Minister, Solicitor-General, and also as Chief Crown Prosecutor. I'm a lifelong summer resident of Southampton in Saugeen Shores. Personally, I am pro-nuclear energy, and I am an admirer of Bruce Power, not only for their economic contribution to our community, but for their good corporate citizenship. On page 1, I set out the two issues that I want to deal with. The first is the requirement of an unbiased appearance, or stating it another way, the question is there a reasonable apprehension of bias? The second issue I'll come to last. Let me go first to brief facts relating to the first issue, which are found in section 2, the bottom part of page 2. 2.1, I point out, as you now know, that between 2005 and 2013, there were at least 17 what we describe as secret illegal meetings of Bruce County Council. Illegal because they were in violation of section 238, 239 of the Municipal Act, which require not only open meetings, but minutes to be taken and notice to the public, and none of those three conditions were followed with any of those meetings. Over on page 3, I'll leave to you paragraphs 2, 3, 4, and 5, and take you now to paragraph 2.6. At one of those meetings, the CEO, president of CNSC, is recorded as having attended September 30th, 2009. In addition to what I submit was the obvious impropriety of his attendance, along with that of Ms. McGee, given their role representing the regulator that would be hearing this very hearing. Dr. Binder was quoted as he departed the meeting as saying, quote, he hoped their next meeting with him would be at the ribbon-cutting ceremony of the low and intermediate level DGR. I leave to you paragraphs 2, 7, and 8 and move to the law on this issue, which is found in pages 4 to 9. The first part of the law is what I've described in 3.1 as the primary test. Permit me to just read 3.1.1, the first sentence. The principles that govern the need for an absence of any appearance of perception or bias or predetermined preference or decision-making were established in 2 seminal Supreme Court of Canada decisions. I then refer to those cases, but I take you, if you'll permit me, to the very bottom of the page where there's a bolded part of the quote. What the Supreme Court said was, as a result, the courts have taken the position that an unbiased appearance is in itself an essential component of procedural fairness. At the top of the next page, the test is whether a reasonably informed bystander could reasonably perceive bias on the part of the adjudicator. I have tried in the next paragraph to give you a form of words by which you might ask the question that would help you, guide you as to the application of this test by asking whether a reasonably informed bystander, for example, the reasonably informed ordinary citizen of, say, Saugeen Shores, could, not would or should, but could reasonably perceive bias on the part of the panel. The mere existence of a reasonable possibility is damning to the decision-maker's ability to be perceived as an unbiased decision-maker, regardless of his or her actual views. Now, before I go any further, I want to make it clear what is made clear later in the written submission, and that is there's no suggestion on my part that any of the three of you has indicated anything to suggest individual bias or conflict. That's not the point. I will take you to how what we do perceive as bias is brought home to be relevant to you as a panel. But let me continue with respect to the law relating to what Dr. Binder did on the 30th of September. Paragraph 3.2 is an examination of what the courts have said about the fact that there are different kinds of administrative tribunals in this country, some of them more adjudicative in function than others, some more policy in function. Based on the authorities, I believe the situation is very clear that your tribunal, as you said, I believe, Madam Chair, at the very outset on day one, is a quasi-judicial administrative tribunal. I think those were your words. That does perform an adjudicative function. So I don't think there's much doubt, but I'm only one person looking at this, and so I've provided you with the law relating to the alternative test should you decide that I'm wrong and that you are a policy-making tribunal as opposed to an adjudicative one. And I have to say that the cases make it clear that no tribunal is exclusively one or the other. Every tribunal has some of each function. The question is, do you have enough of an adjudicative function as a quasi-judicial function to test this question by way of this primary test of reasonable apprehension of bias? Now, based on the case law, I would take you to 3.3.1, where there are three separate points made. The first, and permit me to briefly read, to apply the unbiased appearance test, it may be helpful, as I've already said, to ask the question as, would it be unreasonable for a reasonably well-informed lay resident of Kincardine, for example, or an adjacent community, to apprehend bias when the person in charge of the regulatory process appears to have declared his expectation that the project is effectively a foregone conclusion, given the reference of the President to the ribbon-cutting ceremony? In the next sentence, moreover, could reasonable citizens reasonably have their apprehension escalated when the utterance occurs in a secret, illegal meeting with the proponent and the municipalities the proponent has paid for support? When one looks at the history of Anglo-Canadian administrative law relating to these issues, this is disturbing conduct by such a decision maker. It seems reasonable to infer that a reasonable and well-informed resident of these communities would be shocked and disturbed to learn of these facts. And so that reasonable citizen would not only could, but likely would apprehend partiality. Let me go quickly then to paragraph 3.2.2, and I'm going to have to skip here quickly. I don't have to refer to the cases dealing with the alternative, but I do at the top of page 9 in paragraph 3.3.5 make the alternative submission that even if the lower test is the applicable one, Dr. Binder appears to have prejudged, and moreover he has done so in a very questionable setting which is impossible to undo. Representations to the contrary of the prejudgment would be futile. All right, how does all of this relating to Dr. Binder apply vis-a-vis this panel? This is the more difficult question. And to answer that question, one has to look at the agreement between the Minister of the Environment and the CNSC to establish this JRP, and to look at Section 22 of the Nuclear Safety Control Act, because those documents make it clear that your jurisdiction as a panel is not completely open. Your jurisdiction is limited by the wording of Section 22, which says you will act, quote, as directed by the President. Since the statute makes it clear the JRP is bound to exercise its mandate in this way, it is unavoidably tainted by the reasonably apprehended bias or even closed mind of the President, regardless of whether there's a complete absence of fault on the part of any of the three of you personally. I leave that section by simply a reminder in 3.5 that the law makes it clear it's an appearance of justice that counts, not the fact of justice. Finally, I go to what should you do about it? I point out in 4.1 that one option would be to simply abort this hearing. I also go on to say that to do so and simply repopulate CNSC doesn't really address the root problem. I suggest in 4.2 a more prudent course would be for you to wait, hear all of the other submissions relating to procedural unfairness, defects in the process, and there are many of them, because it's my submission that when you hear those, as set out in paragraph 4.3, you will then be able to consider their cumulative effect, and that cumulative effect should lead you to a conclusion that the proceeding cannot continue. In my submission, as I said finally in 4.4, whether clothed as OPG or NUMO, the evidence shows plainly that the nuclear energy producers have demonstrated they will not participate fairly in a transparent manner. The evidence also shows plainly that neither have nor will the Bruce County municipalities participate fairly and in a transparent manner. Regrettably, because of Dr. Binder, it appears also plain that the CNSC has allowed itself to get too close to the very proponent that it is supposed to be hearing, along with all the other interested parties. My last point is my second submission, and that is one more of information than either expertise or interest. It's based on the fact that in 2004 or 5, I was president of the Southampton Residents Association, an office now held by Ken Robertson. And in short, as I've said in very few words in my written submission, the residents of Saugeen Shores were seriously misled. The deal at that time was you not only get cash from OPG, but if you go along with this cash for support deal, yes, you're supporting DGR1 in Kincardine, but you'll never have to worry about DGR2 for high-level waste anywhere in Bruce County, let alone in Saugeen Shores. Thank you.